Josh, do it now! David, try to...
They're impetuous. They're frankly not thinking.
The reason that kids take more risks than adults, we think, has to do with this mismatch between this easily aroused emotional system and the more rational self-control system. Kids may be more likely to overlook the downside of a risky decision.
And what this medical science was showing increasingly is that the key portions of the brain, which control impulses, which allow somebody to look at the consequences of their actions, in 16, 17, 18-year-olds are not developed yet. That evidence, that science really caused people to reflect. As I think the genius of the Eighth Amendment requires prosecutors and judges to do.
In other words, as we learned more about the brain, about what's normal in a brain that hasn't fully developed, the courts adjusted. Our standards of decency evolved when it came to the Eighth Amendment.
The court over time has said that a number of things are prohibited by the Eighth Amendment as it relates to the death penalty.
For the first time, the Supreme Court identified a class of offenders who it ruled could no longer be subjected to the death penalty.
But it wasn't a juvenile offender. In 2002, the court took up the case of Atkins versus Virginia.
The Atkins case required the United States Supreme Court to consider whether or not, under the Eighth Amendment, we could constitutionally execute individuals who were intellectually challenged.
In 1996, Darrell Atkins was convicted of murder and sentenced to death, but he only had an IQ of 59.
Everyone's taken an IQ test. Average score is 100.
His lawyers took the case all the way to the United States Supreme Court, arguing that he could not be held as responsible as others convicted of murder because he lacked the capacity to fully understand the consequences of his crime.
The person has to understand what their likelihood of being apprehended is, what the magnitude of the punishment that they're being threatened with is. So it's hard to imagine somebody with a certain IQ actually demonstrating that kind of sophistication.
The American Psychological Association and American Psychiatric Association wrote briefs opposing the death penalty for the intellectually disabled based on developments in the science of juvenile brains.
The American Psychological Association and other sort of experts in the field weighed in as amicus curiae, as friends of the court, and provided the Supreme Court with real expertise about the current standard of science and the understanding of human brain development.
Writing for a 6-3 majority, Justice John Paul Stevens applied the evolving standards test. He said in language that seemed appropriate in its day, "We can't impose the death penalty on a defendant who essentially didn't understand what they were doing. Construing and applying the Eighth Amendment in the light of our evolving standards of decency, we conclude that such punishment is excessive and that the Constitution places a substantive restriction on the state's power to take the life of a mentally retarded offender." And unlike in the Furman case that stopped the death penalty back in 1972, the court ruled this time that most states had clear standards when it came to the death penalty. They refused to sentence intellectually disabled people to death.
It was clear that there was a consensus in the country that people with intellectual disabilities are not sufficiently blameworthy to be subjected to the death penalty.
About 30 states had outlawed the practice of executing the intellectually disabled, and the court said at that point there was a national consensus.
And that consensus set a new standard. The science around the development of the brain had changed minds, and when most of the states refused to execute the intellectually disabled, the court ruled in Atkins that our standards of decency had evolved. If you were intellectually disabled, you couldn't be executed just because you happened to live in one of the few states that were outside of the consensus.
Atkins, in many respects, really provided the blueprint for the next challenge to the death penalty, which was a challenge to the death penalty for 16 and 17-year-olds.